If you're renting in Louisiana, it's important to know your rights and what to expect if you ever face eviction. Today, we're going to walk you through the eviction process step by step so you can feel prepared and protected. Let's get started. Eviction is a legal way for landlords to remove tenants from a property. There are several reasons you might be evicted, like not paying rent, violating your lease, or if the landlord decides not to renew your lease. No matter the reason, the process must follow the law. Step 1. Receiving a notice to vacate. Everything starts when the landlord provides the tenant with a notice to vacate, stating the reason for eviction and the time frame in which a tenant must vacate. The notice should clearly state why you are being evicted and give you a chance to fix the issue if possible. For example, if you haven't paid rent, you should receive a 5-day notice to pay or leave. Always read these notices carefully because the type of notice can vary depending on the eviction reason. If you can't resolve the issue, like paying overdue rent, the next step for your landlord is to file an eviction lawsuit beginning the judicial eviction process. Check your lease to ensure that you did not agree to waive the notice requirement in the lease. If the landlord and the tenant agree that no notice is necessary, this should be explicitly stated in the lease or in a written agreement to avoid any potential legal disputes. Step 2. Court filing for the rule for possession. The landlord begins the judicial eviction process by filing a rule for possession in court, which is a formal request for the tenant to show why they should not be evicted. The rule for possession should clearly state the reasons for eviction, matching those given in the initial notice to vacate. The court then issues an order or citation to the tenant, telling them why they should be allowed to keep living there. The rule for possession gets served or delivered to the tenant by a sheriff, marshal, or constable. This can be done by attaching the notice to the tenant's door or by sending it through the mail. This ensures the tenant is fully aware of the eviction proceedings and allows the tenant to respond with their defenses to the eviction. Step 3. Prepare an answer with your defenses to the eviction. When you're facing an eviction and need to prepare a response, there are a few steps you should follow, which include determining the reason for eviction, identifying possible defenses, preparing an answer and having it notarized, and filing the notarized answer in court. By identifying the reasons for the eviction and your legal defenses, and then officially submitting your response, you inform the court that you believe there are valid reasons why you should not be evicted. Step 4. Court hearing. The hearing for the eviction cannot take place until at least 3 days after the eviction notice is served or delivered to the tenant. This gives tenants a brief period to get ready to defend themselves. Both parties then present their case in court during what is known as a rule to show cause or a summary proceeding. These types of court hearings are usually quicker and less formal than regular legal procedures. During the hearing, both the landlord and the tenant present their evidence. Landlords need to clearly show why they are evicting a tenant. This includes proving there is a landlord-tenant relationship, that the tenant has violated the lease or given another reason for eviction, and that the notice was properly delivered. Tenants should prepare to defend themselves. They should make sure to bring any witnesses or evidence that helps their case, such as payment records, communications with the landlord, photographs of the premises, and any other relevant documents. Should a tenant not respond or appear for trial, the court has the authority to issue an immediate eviction judgment with a very short, 24-hour period notice for the tenant to vacate. Step 5. Eviction order is issued. If the court rules in favor of the landlord, it will issue an eviction order or judgment right after the trial ends. This happens quickly in eviction cases, with the court immediately providing a formal written judgment. In some cases, the judgment might dismiss the case in favor of the tenant or lead to a consent judgment where both the landlord and the tenant agree on the terms. The tenant will receive notice of the judgment to ensure they fully understand the court's decision and their rights, including the right to appeal the eviction. If you filed a formal response to the eviction notice, you can challenge the eviction by appealing within 24 hours after judgment. To proceed with an appeal, you must also post an appeal bond. This bond is a sum of money paid into court to cover potential costs or losses to the landlord if your appeal is unsuccessful. Step 6. Law enforcement removal. If the tenant doesn't leave the property even after the court has ruled in favor of the landlord, law enforcement officers can step in to remove the tenant. This usually happens if the tenant has not vacated the premises within 24 hours after the eviction judgment. The process involves law enforcement physically removing the tenant and their belongings from the property. Facing eviction can be stressful, but knowing your rights is a powerful tool. If you're ever unsure or need help, reach out to a lawyer who can help provide support and information, guide you through the eviction process, or even represent you in court. For more resources or to find help, visit our evictions page on louisianalawelp.org. Stay informed and take care of yourself. Thanks for watching.